Start, Guru. Start. Very good morning to you all. A good, superb morning. Welcome all of you all to this special talks with Mr. Housing Guru and Master, Mr. Ramesh Prabhu. And also on behalf of Mr. Sharma, he should be here next week with y'all. He is on his way back to the city, and then probably he'll join y'all next Wednesday. So this is your host for today, Kaivan Irani, and welcome again. I promise the most profound experience today, right now, because you deserve the best. Today the topic is of nomination and the law of inheritance. Now, before we begin, I'd like to request Mr. Prabhu to elaborate a little on the importance of nomination and the law of inheritance.
Yeah. So first of all, let us understand what is the difference between nomination and law of inheritance. See, normally in different provisions of the law, the nomination is being captured, especially in Maharashtra Cooperative Societies Act also. We have section 30 of the Maharashtra Cooperative Societies Act, which talks about nomination. On the demise of a member, whom the right title interest in that of that particular member in the property of the society will get transferred as a trustee. Nominee is always considered as a trustee. So we know that there are two types of properties. One is about movable property, second is about the immobile property. In the case of a movable property like LIC or a bank or a fixed deposit, securities, once we make a nomination, or even in the case of a company share certificate, once you make a nomination, naturally those certificates are getting transferred to the nominee, and again the various high courts and Supreme Court's judgments have held that the nominee is only a trustee. So it is the duty of the nominee to represent all the legal heirs and then as a trustee, and then get the amount distributed in the way that deceased person wants it to be divided or distributed. Now what happens is, in the case of nomination, as I said, nominee does not become the owner of the property, he becomes only the trustee of the property in the case of immobile property. In that case, the law of inheritance will come into picture, and the nominee, it is a duty of the nominee to bring the legal heirs as per the law of inheritance on the records of the society. Till the person who is going to inherit the property as per the law of inheritance, the name of the nominee as a trustee will be continued in the share certificate as a provisional member. So the word used is a provisional member. A nominee gets a provisional member, and the person who is a legal heir under the law of inheritance will get the membership of the society. Now, what are the law of inheritance? Now, law of inheritance is always based on the personal law by which they are governing. Let us say if I am a Hindu, then Hindu Succession Act will be applicable to me. Whenever I bequeath my properties, or when I leave this world, definitely I will be and my children will be governed by law of inheritance of Hindu. If there is a Mohammedan, then the Mohammedan law is applicable. In the case of other community, then we have an Indian Succession Act. So this is how the law of inheritance is governed. Now secondly, in order to inherit under the Indian Succession Act, yes, a person also can make a will. So if a person is making a will need to be probated as per the Indian Succession Act, and of course the will be probated by the testamentary department of the various districts and also the high courts in Mumbai. So this way, the law of inheritance, in order to inherit the property, whether it's a movable or immobile property, is the most important thing. Now, in order to succeed the movable property under the law of inheritance, we call it as a succession certificate. So if there is a movable property, it will be succession certificate. If it's a only immobile property, there will be a letter of administration or a probate. And if there is a combination of what is known as the movable as well as immobile property, then we get a succession certificate. So this is how under the law of inheritance, considering the personal law applicable to those person who is deceased, their legal heirs will get the property. With this, I think I have given the background Now you can throw me the questions, whatever has been asked by the participants, Mr. Kevan here.
Perfect. And thank you, Mr. Prabhu. Thank you for enlightening the audience as well as ourselves on the law of inheritance and nomination. So we'll move ahead with the questions now. Now the questions have come from a gentleman by the name of Mr. Pankaj Shah. And this gentleman is from Villepale in the city of Mumbai. And the first question is that if the property is in a joint name, meaning 50% holding, right, ratio, the nomination has the nomination to be done by each holder in separate nomination forms. That's the and nominees, can the nominees be different for both in both the forms?
Very good question. It's practically this type of questions are asked. Now what happens is, when we say a property is owned by two people, they are called joint owners. So let us assume husband and wife both have got the properties. In that case, both have got a 50-50% right, in the absence of something written in the agreement. In the agreement, if it is said that first owner will have 20%, another owner will have 80%, then there is very much clear in the agreement that it is 20 and 80.
Correct.
However, if nothing is mentioned under the transfer of property, it is understood that both have got a equal rights, 50-50. Now, having said that they are the joint owners, naturally every owner has a right to nominate. So therefore, in such cases, both the people can give two different nomination forms. That means Mr. A and Mr. B both need not die at the same time. If they are signing at the same time, if that is the wish of the God, then it may happen. But otherwise, in the normal course, A and B may expire on a different time. And naturally, A has a 50% right, B has a 50% right. So on the demise of A, whom he wants to get his flat nominated, or who will be his future trustee for after his demise, he can give a separate form. B also can give a separate form. The next question is, can the nominee be separate? The answer is absolutely yes. A can nominate, let us say C. B can nominate D. So absolutely there is no question that they have to nominate the same person.
Great.
And there is nothing called, in the banks we have, because many people are under the wrong impression that if the property is purchased in the name of husband-wife, it will be either and survivor. See, either and survivor is applicable only in the case of immovable property, that too in the banks. But it does not happen in the case of immovable property. Immovable property is governed by the Transfer of Property Act, law of inheritance, and therefore it has to be something in return, and it is by virtue of the law. So therefore, either or survivor is not applicable, and you cannot assume that on the demise of A, the property will automatically go to B. That does not happen. Or on the demise of B, it will automatically come to A. Or if both of them nominate together, that on the demise of one person, the nominee will come into picture. The nominee may not come into picture because that both people have not expired. So therefore, it is advisable that both the nominees should give a separate form, and they can give a common nominee, or they can give us two different nominees.
Great. So thank you, Mr. Prabhu, for enlightening us. So basically, the immovable property is governed by the law of Inheritance Act, and thus the bank laws are inapplicable. 1. 2 is the nominees can be separate. Both of them can nominate whomsoever they might choose or feel appropriately so. So thank you, Mr. Prabhu. Thank you for enlightening us. Now we move to the next question. Again, the next question also is from Mr. Pankaj Shah from Villepale. Now, what are the charges for subsequent changes and new nomination when submitted to the society for a particular or specific property?
Yeah. See, nomination is given by the member or a joint member. Now, it is a choice of him to regularly go on updating the nomination form. He can always change the nomination. Today he is nominating his wife, tomorrow wife is expired, he wants to nominate his brother, third time he wants to nominate his son. So anytime he can go on changing the nomination. So whenever you give a new nomination, the old nomination definitely becomes redundant.
Correct.
Now the question arises, is there any charges applicable? Yes. For every time you give a new nomination, first nomination there is no charges. But second time when you give a new nomination, then 50 rupees is charged as the nominal registration fee. Nomination requires to be registered in the nomination register. Once you receive the nomination, you have to duly acknowledge to the other party. Third, it has to be recorded in the minutes of the managing committee. So there is certain procedure which is required to be done, and therefore to restrict people from every now and then changing the nomination and putting the office bearers into work, a 50 rupees nominal fees are being charged as a change of nomination charges.
Great. So thank you, Mr. Prabhu. So just to advise, the first time when you nominate somebody, it is on the house or complimentary. Subsequently, as Mr. Prabhu said, it has to be, people's time has to be respected. So 50 rupees is virtually whatever you might decide to feel it is. 50 rupees nomination charges are applied, registration charges every time you want to change a nominee. Thank you, Mr. Prabhu. And we move to the third question. Again, that is from Mr. Pankaj Shah from Villapalli. Now, the third question is, if nomination forms are not accepted by the society office bearers. Now, this could be due to ego problems between the office bearers, one of the office bearers. What is the remedy so that the nomination process and acknowledgement process can move forward unobstructed?
See, in the normal course, the society, any letter is issued or nomination issued, they should immediately acknowledge it. Acknowledgement is the most important thing which society should do. They should not at all refuse to acknowledge. The second most important thing is, once the nomination is accepted, they have to record it in the minutes book. Third, they have to also register in the nomination register. In case the managing committee does not record in the minutes book, they do not record it in the nomination register, does it mean that nomination becomes invalid? The answer is no. The moment it is received by the society and acknowledged by the society, as far as the nominee is concerned, or as far as that particular member is concerned, nomination is registered. Now, as you rightly pointed out, there are some societies, they do not accept the nomination. What are the remedies available? One, yes, you can, if you have a society's email address, you can scan the nomination form and send it to them by email. Second, you can send it by WhatsApp also. Third, you can send it by registered post, because once you send it by registered post, that need to be acknowledged. You can always write on the acknowledgement due nomination form nominating Mr. So and so, so that acknowledgement which is issued from the society office bearer or the manager becomes the important thing. Fourth thing, whoever is the chairman and secretary, you can make the nomination and simply drop the letter there. And the last and most important, suppose if this also, after doing all this, you are not satisfied, what you can do is you can write a letter to the registrar of a cooperative society with a covering letter that these are the nominations which have been sent by registered AD and by WhatsApp, by email or by hand delivery, but I am not getting a due acknowledgement, and I request you to send it to the concerned society with your forwarding letter. So in that case, the deputy registrar will forward it to the society, and that is how you can also get it acknowledged. So I think these are the methodology which one can adopt and get your nomination registered.
Great. So there is a lot of remedies that Mr. Prabhu has provided, remedy processes. So you can opt either for one or multiple. The more, the better, because you have multiple evidence in terms of the process that you have implemented. Thank you, Mr. Prabhu. And now the third question again is from Mr. Pankaj Shah. How many times legally can somebody change his or her nomination? Meaning,
I think I have already said this. A nomination form is valid till you change that nomination, and it will become effective only after the demise of the member. So therefore, there is no restriction as to how many times you can change the nomination, but every time that you change the nomination, you have to give a covering letter saying that the old nomination becomes redundant and this is a new nomination form, and you have to pay 50 rupees fees for changing the nomination. So there is no restriction, you can change any number of times.
Great. So you can do it umpteen times. Every time, of course, you will have to incur the cost of the 50 rupees of registration and changing of the nominee. So you can go ahead and do it any amount of times. Now the next question again is from Mr. Pankaj Shah. Now here the society registrar has directed the society office bearers to accept the nominations and update its records, books of records. And even when the society, suppose the society fails to follow, do the needful as directed by the society registrar, how can this be dealt with efficiently?
I think I have made it very clear in the beginning that in the case of a nomination there are two steps. One step, the action that has to be taken by the member. The second step is the action that has to be taken by the managing committee or the secretary. Now let us assume that the action what member has to take, he has to fill up the nomination, take the witness and submit to the society, give acknowledgement of it. And if he is not acknowledging, of course through the register or any other mode that we discussed, it can be dispatched. Having dispatched, the nomination as far as that particular member is concerned and that particular nominee is concerned is completed. Now the society, it is a duty of the society to get it recorded in the minutes book. Having said that, these are the nominations received in this month and these are the nominees, that should be recorded in the nomination form, and thereafter it has to be recorded in the nomination register also. Not only in the minutes book, in the nomination register. But these both actions, as he has rightly pointed, even after repeated request from the registrar, that has not been done by the committee, will it affect the nomination? The answer is absolutely no. There is n number of judgments of the High Court and the Cooperative Court and also the registrar. Once the nomination is reached to the society, and if because of the certain lapses on account of the society's office bearer, the nomination does not become valid, it becomes a valid nomination, and thereafter on the demise of the member, the nominee's name, the flat has to be transferred.
His next question is there a penalty to the office bearers who failed to fulfill their obligation of doing what they were supposed to do?
Yes, as on today, there is no specific penalty which has been levied or which has been set in the bylaws. But naturally, if somebody is not doing their duties properly, you are always free to approach the registrar. As you said that the registrar also, let us say, sends the letter, gives the direction that it should be recorded, still it is not recorded, that means it is disobeying the order of the registrar. The moment you disobey the order of the registrar, that means you have committed a contempt of the registrar's order.
Correct.
Or the obligation that you are supposed to carry out, in spite of giving the
Because
direction.
they are the regulatory authority, right?
Absolutely correct.
So,
In such cases, yes, the entire committee who are in default can be dismissed, and of course 5,000 rupees penalty also can be levied on them, and ultimately they also may be dismissed and disqualified from contesting election for the next full one term of 5 years. So therefore there is a huge penalty and the consequences of not carrying out the duties cast on them or the orders given by the registrars are not complied by them.
great. So there is implications the committee will face probably, and penalty and leave it, and also they'll be disqualified. So for 5 years they are going to be unable to run. So you can convey this message to anybody who fails to fulfill their obligations, especially on the managing committee. Now, the next question is nomination sufficient proof for society to accept and do changes on the share certificate and transfer the property if there is no will, if the will is absent, if the will is absent, that meaning the deceased person has failed to provide a will or prepare a will? And is there any judgments by the high court in the honorable high court for any of these cases? Like, have any cases gone to the high court and has any judgment been passed about the same?
Yeah. Now, it is the duty of the society. Once there is a registered nomination in the society record, it becomes the obligation on the society to transfer the shares provisionally in the name of the nominee. So that means the shares will be transferred to a nominee and they will be called as a provisional member. It becomes the duty of that provisional member to bring the legal heir on the record, and thereafter only acquire, that legal heirs will acquire the rights in the property. Till such time, the nominee can of course attend the meeting, contest the election, become an office bearer, but they will be considered as a provisional member. Now the second question is whether there is any judgment. Yes, Indira Wahiri, a judgment of Supreme Court, which was of the West Bengal Cooperative Societies Act, where nomination was made and the society did not transfer, the register also did not transfer for some reason, and matter went to the High Court and then the Supreme Court. Supreme Court has categorically said, once there is a registered nomination, it is the duty of the society, irrespective of any claim by anybody, to transfer the name in the name of the nominee. And if there are any aggrieved people or who are contesting for the property right, then they have their individual right under the law of inheritance, and they can go to the civil court and get the remedy done. So society, just because somebody issues a legal notice, somebody says something, or there is an objection from the legal heirs, they cannot stop from transferring the provisional membership or giving a provisional membership to the nominee.
Great, Mr. Prabhu. So there is clarity here. So the society must follow the rules and regulations that they are supposed to do. Now, is there any? Can the society, in this case, should the society still ask for a succession certificate?
Yeah. See, as I said, nominee is a trustee, and nominee is made as a provisional member. In order to give the ownership right of that property to the nominee has to bring either a will, which is duly probated, or a succession certificate along with the movable property, or a letter of administration in respect of only what is known as immovable property. Letter of administration in the case of immovable property. This is also possible if it is in Mumbai, testamentary department, all the documents are available. If other than Mumbai, they can get a heirship certificate from the district court, they can take that. And last is, in case all this is not possible and it becomes costly for them, and if there is a consensus among the legal heirs, they can also get a release deed executed. For example, husband is there, he is expired, there is a wife and 2 children. Then wife and 2 children can always enter into a release deed. The 2 children can release their right title interest, because on the death of a husband, wife and 2 children, okay?
Yeah.
And if there is a mother, then mother. All these 4 people will get 25%, 25%, 25%.
Equal rights in the
equal rights.
equal percent.
If mother is not there,
Okay.
in that case, wife and 2 children
Correct.
will get 1/3, 1/3.
One third, one third, one third.
So, in case nomination is in the name of wife, initially wife becomes the
Trustee. Correct.
and provisional member. Then if those 2 children give the release deed, releasing the right title interest of 1/3, 1/3, by executing a release deed, by registering that release deed on a stamp paper as applicable. In Maharashtra we have 200 rupees stamp paper. You make a release deed and register that release deed, and then of course in that case you are required to pay only 200 rupees release deed, get it registered by paying 1000 rupees, and then you become the full owner. So one is a succession certificate,
Correct.
or letter of administration. If there is a will, there is a probate, or at least a family arrangement or a release deed.
Now, in the case of the children being minors, would they be able to have the authority to sign the release deed?
In that case, of course, mother being a guardian, she
Correct.
can sign on their
On their behalf. Okay.
and then get the release deed executed.
Okay, great. Thank you, Mr. Prabhu. I hope, I'm expecting that we have clarity, we have real clarity, and Mr. Prabhu has enlightened all of us in this given situation. Now we move to the next person's questions. Mr. Austin Pinto from the city of Mumbai. My question here is that his question is, in case of the society going in for redevelopment, what are the rights of the nominee who has become a provisional member on the demise of the original member or the original owner?
Very good question. As I said, the provisional member, the word provisional member is used in order to give a sense of urgency for them to bring the legal heirs on the record, because provisional member again becomes a trustee. No doubt, as a trustee, they can sign the what is known as development agreement. They can give the consent in the process of redevelopment, and if there is going to be new flat which is coming in, they can also by that time bring a letter of administration or a section certificate or probate or whatever is available, or get the release date registered, so that the permanent alternate accommodation also can be executed in the name of real owner. In case real owner is not available, then the nominee also can get the letter of this permanent alternate accommodation registered in their name, saying that they are provisional member and they are the trustees of the legal heirs. So by doing that, they can also proceed with the redevelopment. There is no problem.
Great. So that means his next question was, can they participate? You've already taken care of that question, so they can go ahead and do the needful. Now the third question is on the basis that the nominee can sign the redevelopment agreement. Will the developer give the nominee the hardship allowance, rent, and corpus, meaning the various things? And if no, then who holds the amount, meaning the society or the developer, till the heirs, legal heirs, come on board?
Legally speaking, the rent has to be given, because if the nominee is occupying the flat and the redevelopment, when the building is getting demolished, the transit accommodation has to be given, so the rent is normally given.
Right.
And even the corpus, and as I said, the position of the flat also need to be given to the nominee, because they are the trustees.
Correct.
So in the deceased member has already indicated to the society that they will be the trustees. They have to do. But however, some of the societies, what they do is they give the rent. But as far as corpus is concerned, they retain with the society, and as and when the legal heirs come with the proper appropriate court order, then only they give the corpus. Otherwise, corpus is always withheld by the society, and as far as position of the flat in the new building is concerned, it is always given to the provisional member or the nominee.
Great. So that takes care of clarity, meaning you have the corpus is held by the society, and the unit is handed over to the nominee. Now we have the final question again from Mr. Austin Pinto from the city of Mumbai. That seems to be a lengthy question, meaning it's quite a bit. So he had asked a question last week whether a nominee can be given a flat on leave and license, right? To which you said that the nominee could not sell or give on a long-term lease, but the nominee could give up the flat on a 11-month leave and license agreement. In the interim, the societies has had sent the same query to the Housing Federation, and their answer came back as follows: the nominee has to hold the flat in the trust and bring the heirs on record, and then pay the maintenance charges without creating any third party rights. Okay, and therefore the nominee member cannot sell or mortgage or put on leave and license like alienate the flat by virtue of holding the flat or the unit. I request you to please bring clarity on the leave and license issue.
No, the question is very much relevant. See what happens when you give flat on the leave and license basis. According to me, you do not create third party right in that. See, third party right is created only when there is a lease or when there is a mortgage, when there is a sale. But in the case of a leave and license, it is a permission that you give for a temporary period, so that the nominee will be able to take care of the maintenance of the property very well, and the temporary period you can earn the income out of it, so that that income can be used for the welfare of the legal heirs. Now there are different thoughts process, different thing. If you want to be very strict and you don't want that that flat may be locked, if it is not maintained, that is fine. If the maintenance is also not coming, it's fine. If there is a dispute, let that dispute continue between the nominee and the legal heirs. So in such cases, if a society takes a stand, and they are also right, I am still saying the society is also right in not allowing leave and license. But in all fairness, and if you look at the Easement Act also, leave and license is a temporary license is given. The word itself says it is a leave and license. It's a temporal license given by the nominee to a person to occupy the premises. Even under the, this one, what you call, our Maharashtra Public Trust Act, if a trust wants to give a property, because they are also trustees, they want to give the property on leave and license basis for a period of 1 year, 2 years, or 3 years, up to 3 years.
Correct.
You don't require, permission from the Charity Commission.
Correct.
But if you want to mortgage, you want to sell, you want to create a third-party interest, say mortgage, sell, in that case, or give on lease basis, in that case, permission from the Charity Commission is required.
Correct.
I am just taking that analogy here, but it is again up to the society to decide whether to allow leave and license or not. I am not saying that is there any law which specifically says that leave and license can be allowed. The answer is no, because ultimately the nominee is only a trustee. Trustee has a limited role to bring the legal heirs on record, and till such legal records are brought on legal records, legal heirs are brought on the record, they should not alienate the property. I agree with that.
Perfect, perfect. And so we've well, the thing is, he's asked one more question. I think it's relevant to that same thing. So what he says is, request you to lease. Yeah, so that's fine. Bring clarity, and yeah, so this should be okay. Now he says that then they have to shell out the maintenance for the upkeep of the flat, and so it makes more sense that they leave and license the
That's
flat.
what I told you.
That's what you said. So we covered. Now, is there anything else you'd like to add, or any other value questions you'd like to put in or contribute in terms of the participants?
Yeah, I would say that nomination is not an ultimate document. It's only a trustee. So therefore, if you are nominating somebody, please give the nomination form. Along with that, you also make a will, which is very, very important. Because making a will is equally important, because after the demise of you, whom that property should go as a will. Second, one more suggestion is that when you are making a nomination, please make the nomination in the person in whose favor you are making a will. It should not happen that you nominate wife and you make a will in the name of son. Then it will create a rift and it will create most misunderstanding. So with this, please follow the procedure given in the bylaws, given in the act, and help the nominees to get their names on the record, and also help the legal heirs to come on the record of the society, so that society should always be a facilitator and they should not be making any hurdle for the family who are in loss of their loved ones. Thank you very much.
Great. So thank you, Mr. Prabhu. So the key here is when you create a will, you create a legacy. When you create a legacy, what you're doing is even though you pass into the other world or wherever you go, you still have some element of control, and your legal heirs or the people who inherit from you remember you, and the memories are positive and pleasant. So
with this, I can only tell you that if you have any further queries, yes, you are most welcome to write to our office on msw.hsg@gmail.com, or else you contact our association office 022 4255 1414 or 022 4255 1425 or 022 4255 1432.
Great.
Next week we'll come back to a very important issue where the projects are getting delayed for an inordinate period, and the builders are saying that we have taken an extension in the RERA. So what is the remedy available to the flat buyers who have booked the flat, but till now, even though in the agreement it is saying the possession will be given by 31st December 2018, 31st December 2019 or June 2018, something like that, and in spite of over a period of 1 year, 2 years, they are not getting the possession. Members are paying the rent, they are paying the EMI, and they do not know when the project will be completed. What is the remedy available then to them under RERA? So the next week topic is remedies to the flat purchaser in case of delayed possession. Thank you very much.
Thank you, Mr. Prabhu. So keep in mind the other one, the next week, next Wednesday, 12 p.m. is extremely important. It provides you with remedies in case you or somebody who you know is basically having a lot of agony in terms of delay of possession of the new unit or new property. So with this, we conclude. We wish you the best. All the participants, thank you very much. And phenomenal experience right now, and it's magnifying right now. Thank you very much for your time. Make it a pleasant and a great week. Thank you. Bye for now.
Thank you, Max.
Bye-bye.